Section 21C, Non-Judicial Punishment. 21.9, Administrative Procedures. Non-judicial punishment is authorized under Article 15, Uniform Code of Military Justice, UCMJ. Often referred to as an Article 15, non-judicial punishment provides commanders with an essential and prompt means of maintaining good order and discipline and promotes positive behavior changes in service members without the stigma of a court-martial. Any Air Force member can be punished by Article 15. Commanders are encouraged, but not required, to offer counseling and administrative reprimands before resorting to the Article 15 process. Minor offense. Whether or not an offense is minor depends on several factors and is a matter left to the imposing commander's discretion. Besides the nature of the offense, the commander should also consider the alleged offender's age, grade, duty assignments, record, experience, and the maximum sentence imposable for the offense if tried by a general court-martial. Ordinarily, a minor offense is an offense in which the maximum sentence imposable would not include a dishonorable discharge or confinement for more than 1 year if tried by a general court-martial. Procedures. Commanders must confer with the staff judge advocate or a designee before initiating non-judicial punishment proceedings and before imposing punishment. The staff judge advocate advises and helps the commander evaluate the facts and determine what offense was committed. While no specific standard of proof applies to non-judicial punishment proceedings, including appeals, commanders should recognize that a member is entitled to demand trial by court-martial, in which case, proof beyond a reasonable doubt of each element of every offense by legal and competent evidence is a prerequisite to conviction. Whether such proof is available should be considered before initiating Article 15 action. Record of non-judicial punishment. If the commander does determine that non-judicial punishment is appropriate, the staff judge advocate or military justice section of the base legal office prepares the appropriate documentation. AF Form 3070A, Record of Non-Judicial Punishment Proceedings, AB through Staff Sergeant. AF Form 3070B, Record of Non-Judicial Punishment Proceedings, Tech Sergeant through Chief. AF Form 3070C, Record of Non-Judicial Punishment Proceedings, Officer. The commander notifies the member that he or she is considering punishment under Article 15 by signing the appropriate AF Form 3070 and providing it to the member. The form includes a statement of the alleged offenses, the member's rights, and the maximum punishment allowable. After receiving the form, the member has the right to examine all statements and evidence available to the commander and is not required to accept or reject non-judicial punishment sooner than 72 hours following notification. The initiating commander may, upon written application, grant an extension for good cause. Before making the decision, the member may wish to consult with Area Defense Counsel. A member's decision to accept the Article 15 is not an admission of guilt, but is a choice of forum. The member is not required to present matters or make a statement, but may do so orally, in writing, or both, and may present witnesses. 21.10 Punishments under Article 15. If the commander finds the member committed an offense, he or she will determine the appropriate punishment, serve it, and notify the member of the right to appeal. Punishments may include reduction in grade, forfeiture of pay, restrictions, extra duties, and correctional custody. The type and permissible extent of punishment are limited by the imposing commander's grade and the alleged offender's grade. Table 21.1 is provided here as a generalized reference. However, for detailed specific information regarding punishments under Article 15, refer to AFI 36-2502, Enlisted Airman Promotion Demotion Programs, and AFI 51-202 Non-Judicial Punishment. Members' right to appeal. Members are entitled to appeal non-judicial punishment to the next superior authority in the commander's chain of command. The member may appeal when he or she considers the punishment to be unjust or disproportionate to the offense. A member may assert the punishment was unjust because the offense was not committed. Thus, the guilty finding, the punishment, or both may be appealed. The member has 5 calendar days to submit a written appeal. An oral statement is not acceptable. Punishments are not stayed, suspended, or halted during the appeal process. However, if the commander or appellate authority fail to take action on an appeal within 5 days after submission, and if the member so requests, any unexecuted punishment involving restraint or extra duties will be delayed until after appeal. The appellate authority may deny all relief, grant partial relief, or grant all relief requested by the member. The appellate authority's decision is final. 21.11 Suspension, Remission, Mitigation, and Set-Aside Actions. A commander has the power to suspend, remit, mitigate, or set aside punishment of an Article 15. Suspension. To suspend punishment is to postpone application of all or part of a specific probationary period with the understanding that the punishment will be automatically remitted, canceled, at the end of this period if the member does not engage in further misconduct. The probationary period may not exceed 6 months. Suspension may occur when the commander imposes the punishment or within 4 months of executing the punishment. Air Force policy encourages the use of suspended sentences as a corrective tool for first-time offenders to provide an observation period and an incentive for good behavior. Remission. Remission is an action whereby any portion of the unexecuted punishment is canceled, normally used as a reward for good behavior or when determined the punishment imposed was too severe for the particular offense. Mitigation. Mitigation is a reduction in either the quantity or quality of a punishment. Commanders may, at any time, mitigate any part or amount of the unexecuted portion of the punishment by changing to a less severe form or reducing the quantity. For example, a reduction in grade can be mitigated to a forfeiture of pay. Set aside. Setting aside is an action whereby the punishment, whether executed or unexecuted, is set aside, and any property, privilege, or rights affected by the portion of the punishment set aside are restored. Commanders use this action only when they believe, under all the circumstances of the case, the punishment has resulted in clear injustice.